Good morning, everyone. I'm Yvonne Abcall. I'm the Strategic Operations Manager here at the Department of Workforce Services, and I'm thrilled to welcome you today to our virtual training series, Demystifying Workers' Compensation, a Practical Panel. This series is based on your feedback, and we're excited to cover topics monthly that matter to you most. If you want to know what we have coming up, please visit our website, and we'll have a link put in our chat to see our upcoming sessions, register, and see past event recordings. Today's session will be recorded and it will be available on our website within a couple of days. If you have any questions during the presentation, we just ask that you pop them into the chat or the Q&A feature at the bottom of your screen, and our presenters will answer them at the end of the presentation. The presentation today will be a little bit different. It's a panel discussion with our very own DWS workers' compensation staff, and I got to tell you, you're definitely in good hands. This panel has 50 years of combined workers' compensation claims experience. The first 45 minutes of today we'll spend going through some common questions, and we'll start at the very beginning of the claim, including initial injury reporting, determining compensability. We'll move on to medical treatment, claims management, employer responsibilities, disputes, and fraud concerns. The last 15 minutes will be an opportunity for you, the audience, to ask any questions that we may have missed. So again, feel free to use that chat or Q&A feature, and we'll try to get all of them answered. We do ask with the questions that you keep them relatively general and not too claim specific. And a lot of this has to do with privacy concerns. If you have a question that's specific or potentially complex, we do ask that you reach out to your assigned claims analyst. If for some reason you don't know who you're assigned to, feel free to contact our main number here in Cheyenne. That phone number is 307-777-7441. We'll put that number in the chat, and one of our teams here can definitely help coordinate getting you to a person that can talk to you about that. There are a couple of resources too that we want to make sure that you have in your hands before we get too far into today's presentation. They're really great resources that you can use today, but you can also reference them in the weeks and months to come. And they are the Employer's Guide to Workers' Compensation and the Claimant's Guide to Workers' Compensation. Both of those links we're going to put in the chat as we speak. Now let's dive in. Please help me in welcoming our panel presenters today. We have Erica Pasco, Maria Young, Charlene Mestek, and Leah Keith. We're going to get started with our questions on initial injury reporting and just those immediate actions. The first question is going to go to Leah. And Leah, I would just like to ask you, who is responsible for completing the injury report?
The responsible party for completing the injury report is going to be the injured worker. Per the Wyoming statute, the injured worker has 72 hours to report the injury to the employer, and then that report of injury needs to be submitted to the division within 10 days from that date of injury.
Great, thank you. I appreciate that. The next question that I have is for Erica. So Erica, let's say you get hurt at work and your employer says you can't file a report of injury. What should that person do?
So an employer cannot deny an individual from reporting an injury. I would recommend that the injured worker either obtain a copy of the Wyoming report of injury from our website or to go to any of our workforce centers around the state to get a copy of that form, complete it, and submit it to us for review.
That sounds great. I appreciate that, Erica. Do you ever have situations where maybe an injury report comes in, but the employer doesn't have coverage?
Yeah, that's definitely something that can happen, and I would still recommend that the injured worker submit the form to us so that we can determine if their employer does have coverage or not. They can definitely leave that up to us to make that determination on.
That sounds great. I appreciate that. Maria, I'm going to move on to you. What happens if the employer or the injured worker, or both of them potentially, if they don't sign the injury report?
So it is required that the injury report be signed by the injured worker. The insured or the employer, we want them to sign it, but it is not a requirement for us to be able to move on with the claim.
I have a couple of follow-up questions to that. So let's say you're the injured worker, you have the responsibility to complete the injury report and submit it. And of course you want your employer's signature, but they won't sign it. Or maybe an employer has concerns with the claim and they feel like if they sign the injury report, that makes it look like they are saying that they agree with the incident that happened when they might not. How are those situations handled?
So on the injury report where the employer signs, there is 3 boxes that says yes, no, or unsure if you think it's work-related. So that's the opportunity. And you can always submit the injury report without the employer's signature. The analyst assigned will always reach out to the employer and ask them for concerns and for their signature.
Okay. And who makes the final determination on the claim? Is it workers' compensation or the employer as far as if a claim is opened?
Workers' compensation.
Okay, perfect. Next question, I'm going to move over to Leah again. If an individual is hurt at work and the injury report is submitted, what's the next actions? What happens next?
So once the report of injury is received by the division, it will be assigned a claim number within the first 24 to 48 hours. And then the analyst that is assigned to the employer's policy has 5 days to reach out to both the employer and the injured worker to get their basic questions answered, validate some happenings, as well as make sure all the information that was submitted on the report of injury is the most current. And then after that, the injured worker does have the opportunity to reach out to get any more supporting information, such as the medical records, any witness statements, etc., to be able to make that final determination of compensability on the claim, meaning that the claim will either be accepted or denied by the division.
Oh, perfect. So I'm guessing there's probably many instances where maybe the injured worker didn't report within 72 hours, or maybe workers' compensation doesn't receive that report within 10 days. How is late filing handled by the agency?
So again, during the initial contact with the employer as well as the injured worker, the analyst can ask why the injury was not reported or the injury report filed with the division within those statutory time limits. So in some cases, a written letter from each party will be needed just to have on file. But at that point, that decision would be made as well.
Great, I appreciate that. Thank you. So you could definitely open the window to our next section. So I kind of want to move on now to determining and evaluating compensability. So compensability meaning whether or not the agency opens or denies a claim. So the next question is going to be for Maria. And the question is, how is compensability determined and what is the time frame?
So compensability is determined when an injury is found to have happened at work within the course and scope of the job. So can it happen at work with what their job duties are? And did it happen at work? For the time frame, it's kind of confusing, but it's within 60 days of the date that we receive the injury report, or within 45 days of the date that we send the initial letter.
Okay, and what's the initial letter?
So the initial letter could be us asking for more information. We didn't get a hold of them. We need medical records, late file, signatures.
Perfect. So the initial letter isn't necessarily an initial letter opening a claim or denying a claim. The initial letter would just be, I'm asking for more information.
Correct.
Because I can't make a decision yet.
Yep.
Okay, that makes sense, absolutely. And the next question I have is for Erica. And, you know, I bet you there are times where injured workers have pre-existing conditions. So what happens if an injured worker has a pre-existing condition when they get hurt? Is the employer responsible for those claims?
So this can be a very tough situation to handle. Every situation in this type of scenario is going to be different. And we're obviously not going to be able to go over every possible outcome. But hiring an individual that has a pre-existing condition is in a way kind of like buying a used car. You're hiring them as is. So if they are to get hurt at work again, and there is a new compensable injury, then yes, the employer could be responsible for that injury. However, the division does have steps in place to determine a baseline to go back to that original pre-existing injury. And once that baseline has been achieved, most of the time, we're not going to cover any further treatment on that injury.
Oh, that makes sense. And so I would guess that that would be like some of what I believe, maybe it was Leo or Maria was talking about the medical records. So I'm assuming that when you're doing that initial evaluation, you're collecting those records to decide if there's something new, and then you can see maybe what was there at the time or before that injury to make those decisions. Would I be correct in that thinking?
Absolutely. A lot of times in these situations, the analyst is going to request the medical records as well as previous medical records to help us establish that baseline.
Oh, that makes sense, absolutely. And that probably makes it a little easier to show what's happening and kind of leave that claim on through the process.
Exactly.
The next question I have is for Charlene. So let's say the employer doesn't have workers' compensation coverage, but the person got hurt at work. I know we touched on this a little bit. What are the person's options?
Well, if the injured worker is employed by an employer in an industrial classification that's not required to maintain coverage through workers' compensation, and they have not elected coverage, then the injured worker would need to contact their employer regarding other options. But now if they're in a classification that is required, then yes, that'll be something that we take care of.
Perfect. And what are like typical occupations that are required to have coverage versus like occupations that wouldn't be required?
Well, there's required coverages are like any of your industry type places like the city of Cheyenne or the city of Sheridan, or a lot of this sorry, restaurants would be underneath a required coverage. Places that aren't a required coverage, some of the school districts are not required. They're actually not required to carry coverage for their employees. It's optional. There's lots of others, but I can't think of them all of them right now. So,
Sorry about that. I put you on the spot, I suppose.
all right.
Yeah, like basically it's your extra hazardous types of occupations is what it sounds
Correct.
like. It are typically the ones that are required, and then maybe ones that don't carry us like high of risk would be more like your optional coverage. But you obviously, I know you've said, I believe Erica did as well, still file the injury report so that we can sort through the nitty-gritty of it, right?
Yeah, that would be correct.
Perfect. That sounds great. All right. Next, let's move on into medical treatment and disputes. So my next question is for Leah. One of the questions I'm sure comes up frequently is like, what types of treatment requires pre-authorization? Like, for example, if a person wants an MRI, do they need to request that directly from workers' compensation? Does it require pre-authorization? Just maybe explain what is a pre-authorization and when would somebody need it?
Yeah, so a pre-authorization is a request that is sent in by the injured worker's treating provider with diagnosis codes, billing codes, supporting medical records. And in some of the cases, the division does have additional paperwork that has to be done rather than just the pre-authorization form. That would need to be sent in as well. After we receive these requests, we do have a team of qualified medical professionals who review all of the information that was submitted by the treating healthcare provider. And currently only surgery or durable medical equipment, also known as DME, is eligible for that voluntary process. And it's just looking at making sure that it's reasonable and necessary towards that original work injury. For DME, durable medical equipment, it's things such as wheelchairs, braces, any of those like secondary things that you'd need other than surgery to help with healing or regaining strength, things like that. So for in the case of an MRI, that's considered treatment, so a pre-authorization would not be needed, nor would the division even consider doing a pre-authorization for that because it's considered treatment by us.
Okay, that sounds good. And so what happens with that? Because I mean, I think a lot of, like, for private insurance, a lot of times they want a pre-authorization for things like an MRI, but workers' comp doesn't. So are there ever any issues with like an injured worker trying to get an MRI covered, or just because it's like a workers' compensation claim, it makes it a little bit easier?
Yeah, so that healthcare provider is more than happy to call into the division and speak with the analyst that is assigned to the claim, and they'll be able to tell them the status, what body parts are on the claim. But essentially, we don't pre-authorize or pre-deny any form of treatment. When we receive the bill for, in this case, the MRI, we would review it for being reasonable and necessary towards the work injury, and at that point, we would make the decision on if it's covered or not.
Okay, that makes sense. Absolutely. Next question I have is for Charlene. Can an employer determine who an injured worker goes to for medical treatment?
Per Wyoming statute 2714-401F, an employer may designate healthcare providers to provide non-emergency medical attention to employees.
Okay, and so then, like, I mean, what happens after that? Like, if I want to see my own doctor, can I, or do I have the ability to direct my own care?
Yes, the employee for any reason can select another healthcare provider. If it's really their choice who they want to see in the end for their care. And the division cannot direct their care, so we let them choose who they want to see.
Okay, that's perfect. And sort of a follow-up to that, what if the employer or the injured worker would like a second opinion? Like, what does that look like?
The employer can require a second opinion from a healthcare provider of their choice. Same with an employee can get a second opinion as well. It kind of all goes back to that we're not going to direct or offer any advice on who they can see or not to see. So it's really up to them who they want to go to. But the employer does have the option that if they want a second opinion of a doctor of their choice, that we would set them up for that.
Okay, that's perfect. And would that be the same as like an independent medical evaluation, or would that be something different?
Usually independent medical evaluations are actually evaluations where we would ask specific questions to get answers to, for example, like, is the current treatment related to the original injury? We're asking very specific questions in independent medical evaluations where a second opinion is just it's a second opinion of their current treatment.
Great, that makes sense to me. And then Eric, I'm going to move this question over to you. So let's say workers' compensation denies the claim. They determine the claim isn't compensable, or some sort of medical treatment is denied on the claim, for example, the MRI. Can that person still seek treatment?
So in those cases, if the injured worker has objected to one of our final determinations, either denying compensability or medical treatment, they can still seek treatment. We're not going to be able to put any kind of stop to them seeking treatment. However, if they have requested a hearing on either one of those situations, any bills related to the issue would not be able to be paid until the hearing is concluded and the injured worker has prevailed in hearing. In some of those circumstances, the healthcare provider does have the option to seek other forms of payment while the hearing is in process. So they could be asking for another insurance company, or it might go to self-pay for the injured worker. So there can be circumstances where an injured worker might get turned over to collections if bills aren't getting paid during that hearing process. If there is no objection to any of our final determinations denying treatment, obviously the injured worker can still seek treatment in those cases as well. but workers' compensation would no longer be responsible to cover that treatment.
That makes sense, absolutely. So I think that that's a great segue into our next group of questions, which is really about managing the claim and the benefits. So I'm going to go back to Charlene on this question. And this has to do with lost time. So how long can an injured worker receive temporary total disability or lost time payments? And how is their need for continued benefits determined?
So temporary total disability benefits, or TTD is what we usually call it. They're available to injured workers losing paid time off from work. Temporary total disability will not exceed an accumulated total of 24 months for the life of the claim unless there are medically documented extraordinary circumstances. The injured worker has to apply for temporary total disability benefits, and the injured worker's healthcare provider must complete the healthcare provider's certification section of the form and submit it to workers' compensation. The healthcare provider states how long the injured worker is expected to be temporarily disabled, and the healthcare provider has to recertify the TTD application every 60 days.
Okay, I'm sure there's some times that obviously they won't need it for the full 60 days. So I would guess then that the healthcare provider might put a week or 2 weeks if that's all they think the person will need. They won't necessarily do 60 days, correct?
Right. It varies on what's going on with their certain circumstance.
That makes sense, absolutely. And then kind of leading into this next part, how is like maximum medical improvement determined? Like when do you know that person is sort of where they're going to be?
So an injured worker's condition, once it's stabilized and they've reached ascertainable loss or maximum medical improvement, or MMI status. MMI is the point in time which is apparent that a physical impairment has resulted from the compensable injury, and the extent of the physical impairment due to the injury can be determined, and the physical impairment won't substantially improve or deteriorate because of the injury. The treating physician or a licensed physician determines if an injured worker has reached MMI status.
So how is that documented? Like, does workers' compensation ask for that information, or is that like something that comes in a medical report, or how do you know when that happens?
They can come in the medical report from when they see the injured worker. It can be on the TTD application, or we do have some letters that we actually send to the providers that actually ask, is this person at maximum medical improvement? If they're not, when do you expect them to be? And then we follow up later on, because we want to make sure that we're paying attention to that so that we can move them on to the physical impairment part of their injury if they have one.
Okay, thank you. I appreciate that. And then Maria, I'm going to send this question over to you. So after somebody has reached maximum medical improvement, does their claim close at that point?
It does not close. The claim, once you reach MMI, the claim remains open as long as all of the bills and indemnity payments or anything that we have going out is related to the original work injury. Every bill that we receive is always reviewed to make sure it's related. But once it reaches MMI, it still remains open until you don't have any treatment or what you're doing isn't related.
Perfect. That sounds great. So then Leah, my follow-up question will be for you. So how or when could a claim close?
So essentially, whether or not a claim closes depends on the severity of the claim. Some injuries, as we all know, are worse than others. Some take longer to heal. And so that really just depends on the severity of whether or not it closes. However, like Maria mentioned, if a claim for benefits, with the example of medical bills, reimbursements, etc., is not received on the claim, our system is automatically programmed to shut down a claim for no activity at a given amount of time. And then once a new claim for benefits is received on the claim, we do have a process in place to be able to review the claim, to be able to open it, or again, going off if the treatment is reasonable and necessary towards that original work injury.
Perfect. So when you say claim for benefits, would that be like temporary total disability, or is that like a medical bill? Like what would be a claim for benefits?
Yeah, so those medical bills, not to get too heavy into it, but the temporary total disability could be a claim for benefits. However, that would take other situations that we would have to look at before we could reopen a claim for just temporary total disability.
So would it be fair to say basically a claim for benefits would be something that someone has submitted that they're wanting some payment and the payment made through their actual like workers' comp injury? Is that
Yes.
a fair statement? Okay.
Yeah.
That works. Perfect. Awesome. Thank you. The next category we're going to move on to is the employer responsibilities and some of those account implications. So Leah, I'm coming right back to you. I'm picking on you. If an employee is like no longer with the company and they're now working for a new company, why is the medical treatment still being billed to the company that they were injured with?
So this is due to what's called the experience modification rating, or EMR for short. It's calculated and from what years that experience modification rating is being calculated on. So for instance, right now we're in the 2025 EMR, and anything that is older than year 2021 is not impacting that EMR. A big factor that plays into the EMR is how the claims analysts, the employer, the injured worker, how everybody comes together and works together to make sure what is being paid on the claim is only for that work injury and reasonable and necessary towards that original work injury. The employer also has the opportunity to object to the decision that the division is making via individual paperwork that they're copied on or get their originals on, as well as their monthly statements that they receive on their EMR.
That's awesome. And so I'm guessing too, you're just talking about the EMR. The EMR follows the employer. So the claim would follow the employer where the person was hurt. So while the claimant may change occupations or jobs, the injury stays with the employer where they were hurt at. Would I be interpreting that correctly?
Exactly, and that goes off of what Erica spoke about earlier, about the used car situation. Once that claim is found compensable with the division and opened, that's why we have those other reviews in place to make sure that we're solely paying for that injury.
That makes sense, absolutely. And I don't remember if you touched on this or not when you were talking about that, but how long is a claim charged to the employer's account?
So a claim is not charged or billed directly. It just increases that EMR score or rating, sorry, for 3 years. So for example, claims from 2024 will only impact the EMR years of 2026, 2027, and 2028. And then for the current 2025 EMR year, we're looking at claims from 2021, 2022, and 2023. And then each year, about early September, the EMR notice for the next policy year is sent out to each employer. And a good resource for this would be reaching out to our risk management department. They are the ones that have all the whole calculations and can talk to you about different discounts and everything. And I believe that that link is going to go in there for the EMR calculator, as well as their contact information that can be found at our website as well.
Great, I appreciate it. Yeah, I know all of that definitely gets pretty complicated, and our risk management team can definitely help answer a lot of those questions for sure. So that's awesome. Well, that brings us kind of into our next category, which is disputes and appeals. So Eric, I'm going to come back to you for a second. So what happens if an injured worker, an employer, healthcare provider doesn't agree with a determination that was made by workers' compensation? Like, what are the options?
So if we have sent out a final determination, any party involved in that final determination has the opportunity to object to our decision. Our letters do have an insert on there that explains the process for objecting to our determination. Usually there is a 15-day response time period, and this is usually the response needs to be postmarked within those 15 days, faxed or emailed to us. And then once the objection is received, the analyst will refer that over to a hearing body.
Great. How long does the hearing process usually take?
So it can vary. Usually it doesn't exceed more than about a year time frame. If it's getting close to that year time frame, it might have to be dismissed and re-referred at that point in time if there's other issues coming up or further information that the attorneys might have to gather. But usually it's not any longer than about a year time frame.
Okay, and I'm guessing that just goes through like kind of a legal process, so it's probably like first come, first serve on the docket. Would I be correct in that assumption?
Correct. We have about 4 or 5 different options for hearing, depending on what the situation might be. So it's going to depend on where those hearing bodies are at as far as any of the referrals that they've gotten. They're going to hear those in order as they've received them.
Okay, fair enough. And then the next question I have is actually for Maria. What happens if an employer has concerns about a claim? So maybe they have concerns right when the injury report is originally filed, but maybe it's like a month or two into the injury and they suspect that the person is doing things that maybe they shouldn't be doing, or just any other questions, like what happens in those situations?
So in the beginning, just like we talked about with signing the injury report, there are those 3 little, I guess, questions on the back of the injury report that says, yes, it's work related, no, or that you're unsure. That's the first time you can kind of let the analyst know what you're thinking. Every injury report that comes through, the analyst calls or attempts to call or emails the employer and asks them if they have concerns. We do our due diligence to try to get some answers. If you at first you're like, yes, it's work related, and then 2 months down the road you're like, I don't know, contact the analyst. Let them know. The only way the analyst has any information is usually from information they receive. We rely heavily on medical records, but if you have any information, you can always let the analyst know. And you can also object to any of our final determinations. So opening up the claim, paying a bill, your EMR statements, anything that comes out, you're always able to object to them.
Perfect. That sounds good. And that kind of moves us into our last area. If there are like potentially like fraudulent concerns. So Erica, like if you think that somebody is committing workers' compensation fraud, what can you do?
So we do have a special investigation unit that does look into fraud claims. If you go onto our main website, under the contact tab, there is a link for reporting fraud. There's a form that can be completed, or there is a phone number that you can call, and we will look into that information.
Great. And I think that concludes our formal questions. And so I know I haven't been able to read all of them in the chat quite yet, but I have seen that we've gotten lots and lots of questions. So we'll move on to, I guess, the audience questions at this point, and I'll just sort of round robin these through our panelists and get those questions answered. So the first kind of area has to do with that initial injury reporting. And I think Leah may have originally answered this to some extent, but it says you had noted that an employee has 72 hours to report an injury to their employer. When we get to the Q&A, can you address a little deeper what happens if an injury is not reported in the 10 days?
Yeah, so there is opportunity during that initial contact for the employer, if you have concerns regarding that it was filed late or reported late to you, therefore filed late to the division. Making that initial contact with the claims analyst, if you know who your claims analyst is, have their email, phone number, shoot them a communication through there, letting them know all of your concerns, or even just a reason why something was late. Sometimes we all have personal lives, so we can be out of town and that will make an injury report late. But that's just communicating with your analyst.
Okay, thank you. I think that makes sense. I think, then the next question, I'm gonna go back to Leah on this one, just because I think it was touched on some of the answers that you had provided. You said it's the employee's responsibility to file the claim, by letting the employer know, and the employer has to submit it. So I think the question is like, who ultimately has the responsibility to send it in? Maybe you can talk to some of that experience.
So we do have a lot of employers that are gracious enough to submit the reports of injury to the division on behalf of the injured worker. However, it still is the injured worker's responsibility at the end of the day to make sure that that report of injury gets submitted. They can reach out to the division, that 777-7441 number, and they can see if there's even a claim number assigned. Like I said, the 24 to 48 hour time window is when those reports of injury are received, and that claim number is assigned to the report of injury. But again, also in the end of the day, it is the injured worker's responsibility.
That's perfect. Maria, I'm going to send this one over to you because I think it has something to do with a question that you had answered about signatures on the injury report. And it says, what if we're in different states and do PDF e-signatures? Is that okay? I'm guessing some states have taken it and some haven't. So what does Wyoming workers' compensation accept?
The employer's e-signature is perfectly fine. For the employee, we like to have signatures, and that's solely because that releases right above their signature line, there's a little paragraph that says, when I sign here, I'm releasing you to be able to get medical records. And depending on the medical facility, depends on if they accept electronic or, signature in pen. So we just ask that everybody sign it by hand so that we don't run into any errors later on with the claim.
That sounds good. That makes sense. Absolutely. Just probably also just from the standpoint of like not delaying treatment or delaying like the payment of bills or other claims.
Yes. Still
Perfect.
send it in, even if it only has electronic. We can
Right.
get moving, but then we just need the signature at some point.
Okay, that makes sense. Absolutely. What happens if the person can't sign it by hand?
So if it's a catastrophic claim, unfortunately, we do have fatalities that happen at jobs. The employer can sign in the absence of the employee. Also, a spouse or a parent can also sign if the injured worker is incapacitated, so they are unable to sign.
Okay, but I'm guessing though, like then if the person does then get better, at least to some extent, then you would probably reach out to get their signature at that point if they're able to.
Correct. Yep.
Okay, that makes sense. Charlene, I'm going to send this question over to you. So if a claim closes and you have to have treatment, like maybe a few years after the claim closes, and it is related, how can a claim be reopened?
We have to receive a claim for benefits. A claim for benefits would be a bill, a pre-authorization request, or a TTD application. Once we would go ahead and review that, and we would have it reviewed by our medical staff, we may actually require an independent medical evaluation to make that determination. Once that's all reviewed, then we will make a determination if we're going to reopen a claim or if we're actually going to deny it. So it is reviewed.
Okay, perfect. And then this one's a little bit different, but I think maybe fits to some extent. What if you have a person who gets hurt at work, but they're not sure if it's work related or not, but they decline to file a claim? Like, what should an employer do in those situations where an employee doesn't want to file a claim?
Well, the employer could also file the claim. Obviously, we wouldn't have the employee's signature, and then that would start that process of asking for additional information like medical records, the employee to sign. if in turn they decide that they're not going to do it, then we're going to deny the claim because we don't have enough information. So an employer can go ahead and file it if they're not sure.
Great. And then I'm gonna ask you one more question and then I'm gonna stop picking on you for a quick second. So you had mentioned, obviously like the extra hazardous occupations versus the non-extra hazardous. The
Mhm.
question is where can they find the list of occupations that are required to have coverage? And this might be a little too specific, but it says, how does professional consulting services such as engineering fit into the required or not required?
Well, I know that under sorry, under our statutes, under Wyoming statutes 2714-108A through G, that has a list of all the different types. You can also contact our employer services and they can tell you if you need to have the coverage or not. And you can contact them by calling that main number that they put up earlier and ask to talk to your employer services representative.
Great, I appreciate that. And obviously, since it's in our statutes, that's because the legislature determines what's extra hazardous and what's not. So at
Yes.
least for Wyoming.
Yes.
Alrighty, Eric, I'm going to pick on you for a second here. And I think this piggybacks actually off of one of the questions that I just asked Charlene. But how does coverage apply to seasonal or part-time employees?
So seasonal and part-time, if they're still employed by an extra hazardous employer or somebody that has opted into workers' compensation, they would still be covered by us. As far as like lost time goes in those kind of situations, we're gonna look at more of the situation as to even if the employee had work to be able to return to, can they return to that work? Even if it would be outside of that season of operation.
Okay, so basically, like maybe they're towards the end of their season, they get hurt, but it's significant enough that it would have taken them outside of their season. You could still technically cover like the medical and the indemnity, like lost wage benefits, is what you're saying.
Correct, yes.
Okay, perfect. I'm gonna give you another one. So we had talked about the MRIs and not needing pre-authorization. So who's responsible to pay that bill if workers' compensation doesn't cover it or determines it's not medically necessary for that claim?
So if we have denied the bill for coverage saying that it's not related or not reasonable or necessary care for the claim, at that point in time, obviously there is the option to object to our final determination, which it would go through the hearing process. But in that case, the medical provider could request another billing source. So if they had insurance through their employer, they could give them that information and have it billed that way, or it would most likely turn into a private pay situation where the employee would be responsible for that bill.
Perfect, thank you. And then there's another question that we have kind of dealing with something, kind of a similar issue. And the question says it's interesting to me that most insurance companies will only pay for maybe 25 or 30 physical therapy visits, but we will pay indefinitely. Can you talk about how like some of that treatment is paid for and what you look for like if it's medically necessary or it's related to the injury?
So those situations can all be a little bit different. We don't necessarily pay physical therapy for the life of the claim. We're going to look at the fact of whether or not it is still reasonable or necessary. Maybe they had an additional surgery that could come into play. We do have a physical therapy panel that does review bills as well, especially if it has come to the case where physical therapy kind of goes on and on and on, and it doesn't really seem like there's an improvement. There's many different options that can come into place, and the analysts will review each one of those situations however they see fit, whether it's to be referred on to the physical therapy panel or have their nurse case manager involved in the claim as well. Also, once the claim has reached maximum medical improvement, most of the time at that point, physical therapy wouldn't be considered reasonable and necessary for that claim, as they should be moved on to a home program at that point in time as well.
Okay, perfect. That makes a lot of sense. And I'm guessing that like the physical therapy panel probably serves somewhat similar to what Charlene was talking about previously as like an independent medical exam. Would that be like a version of like an independent medical exam to sort of determine what's going on with the claim and what's the next best actions to take?
Correct. If it is referred over to a physical therapy panel, usually those providers aren't somebody that's already treating on that claim. They're going to be an outside perspective looking in.
Perfect. Sounds good. All right, Maria, you haven't been picked on in a little while, so I'm going to move over to you. Can an employee collect FMLA and workers' compensation at the same time?
So that depends on the employer's like human resources or what your policy is. We don't have anything in place that goes against or for that. What we pay is considered a benefit, and we are looking to see if they are receiving any wages from working, not any benefits from work, like sick time, PTO, FMLA, things like that. So it's solely based upon the employer's policy.
Great, thank you, appreciate that. And here's another question for you, Maria. Is there compensation for pain and suffering if the employer was negligent?
So usually what we do as far as compensation is going to be if you lost time from work. A lot of it is case by case basis when it comes to like mental health cases, things like that. I don't want to get too deep into it as far as what we look for, but definitely if you have any questions, reach out to your analyst. But usually what we need is something from a doctor saying that you are off work for a particular issue that is related to your work injury.
Okay, but there wouldn't necessarily be separate compensation, and I'm guessing because most claims are extra hazardous and there's like that exclusive remedy, right? There's some legal protection for that employer by having workers' compensation coverage as well, so there wouldn't necessarily be something like third
Nothing's-
party involved.
Nope.
Perfect. Sounds good. This one, I'll give you one more question because it has to do with FMLA, and then I'll stop picking on you for a second. Are team members taxed in workers' compensation and FMLA wages? So maybe what they're truly asking is, are workers' compensation benefits taxed and our wages taxed maybe?
Okay. How I think I understand that, workers' compensation benefits are not taxed. You will not receive a 1099 at the end of the year, anything like that from us. They are all non-taxable. As far as FMLA goes, I am not 100% trained in that aspect, so I'm not too sure on that. But if it's anything like unemployment, I do know unemployment is taxed.
Perfect, sound good. All right, Leah, your turn. So if someone's employer is deliberately downplaying an incident when it was obviously extreme, where would a complaint be directed?
I'm going back to that it is the injured worker's responsibility to get that report of injury submitted to the division. Does it help to have the backing of your employer? Absolutely. But that is where your claims analyst comes into play as well and can sort through whatever is going on between the employee and employer and just look at the raw facts of, did it happen at work? Are the medical records submitted and reviewed to be supporting of this injury happening? Does the mechanism of injury align with the injury that's being reported? Does that answer?
I think so. I definitely think so. And kind of not necessarily along those lines, but let's say you have an injured worker who doesn't want to file a report of injury right away. And then a year later, they say, hey, when I got myself hurt a year ago, that's causing me issues now. What happens in those situations, or what should they do?
So anytime that you feel like you hurt yourself at work, being from a stub toe to a finger amputation, you should still report it to your employer at least. Having that internal report is very helpful to be able to go back in these cases if something does happen. But you're never going to be downplayed or anything for submitting that report of injury regardless. It does say in our statutes that it needs to be reported within a year, so just keep that in mind. However, in any situation, just report that injury to the employer as well as send the paperwork into the division.
Okay, that makes sense. And to follow up on the last question I had asked you, would it fall, like the last question as far as, I don't even remember what it was now, but would it fall under employee discrimination is what they're wanting to know? Maybe the employer's downplaying, I remember it now, the employer's downplaying something that is considered more severe. Could that be considered employee discrimination? I maybe I'll take this one for you, Leah, a little bit. I would assume, and maybe you have more to share with this, if they think that they're being discriminated against, I would assume that they need to reach out to our labor standards department and file a claim for discrimination, and then they can look into that. I don't know if you have anything else to add to that.
Nope, that's exactly what I was going to say. The workers' compensation falls under a large branch of the Department of Workforce Services, though labor standards is part of our quote unquote family and over here at Department of Workforce Services. So that's who I would recommend an employee gets in contact with.
Great, thank you, appreciate that. Charlene, I'm going to move on to you. If an employee is working remotely out of state, how does the employee file the injury report?
Yeah.
So,
Sorry, click the wrong button. We can actually, if they're working out of state, I mean, it depends if you're required coverage. You can definitely send in the injury report. We're gonna have to review if they would actually be covered as that employer, because when we get to working out of state, it depends what kind of classification you're in, if it would be covered or not. But if you're unsure, I would say file the report, let us make the determination to figure out if it would be a covered injury or not.
perfect, sounds good. And then to follow up, another question. Do you get workers' compensation coverage through the state of Wyoming, or do you have to go out and purchase it through an insurance company?
Well, if you're working in a classification that's required, then yes, you should get it through us. But if you're an optional, you can go somewhere else and get your coverage if you want it that way.
Perfect. So the next question says, I apologize if I missed something. And Charlene, I'll give you this one too. Are we submitting these RPIs, maybe it's supposed to be report of injury forms, every injury that has seen initial care but no lost time, or just anything that's going to have lost time? So maybe the question is, do you file it if the person only needs medical treatment, or do you file it if they need medical treatment and indemnity, or what does that look like?
I would say that if you've got somebody that's hurt and they're gonna go seek treatment, file a report, because it can come back onto the employer and you won't have those safeguards that if you do file the report where they can't come back to you. I know that's just like, but that's for everything. I mean, somebody's got to pay for the person's treatment, and it's probably better off. I mean, if the treatment's for like a cut finger, it's not going to be crazy, outrageous or anything, and it probably will not affect your rates overall, unless obviously they chopped off part of their finger. But I think it's just better that if you've got the coverage, you should probably go ahead and use it.
That makes sense, absolutely. And then obviously you're, as an employer, kind of protected too, because, you let them file the claim regardless of what the decision's being made. That makes
Yes.
sense. All right, Erica, I'm gonna come on over to you and ask you a couple questions. what are the boundaries when it comes to questioning new hires about pre-existing conditions when it comes to discrimination?
So I would say that that is also a question to direct more towards our labor services department. They can definitely help as far as what constitutes discrimination and what would be safe hire questions to answer.
I think that's good. And I also believe maybe the federal DOL might have some frequently asked questions out there too that you might be able to find an answer for as well.
Yeah, there should definitely be some online resources for that. Workers' compensation doesn't really have any boundary on that area.
Absolutely. The next question for you, Erica, is if an employee is concurrently on FMLA and workers' compensation, are there any specific steps that need to be taken with workers' compensation in order for the employee to return to work?
We don't necessarily require any steps to be taken for them to return to work. That usually is more on the employer policy side of things. So if an employer has a policy in place where they need to have some kind of fit for duty test or something like that done prior to returning back to work, that's more on the employer. If we've received something from the doctor saying that they're released to work for full duty or restrictions and the employer can accommodate those, that's all we need on our end.
Perfect. Thank you. Appreciate that. And then the next question, I'm going to actually send it to Brenda because I think you touched this one a couple times. So if you as the employer don't agree with the injury, you can note or you can signify that on the injury report when you submit it.
Correct.
Okay.
So right above, oh, sorry, go ahead.
Oh, I was going to say also, should they send anything else in at that same time, like if they disagree with it?
Mm-hmm. So on the injury report itself, there's the yes, no, and unsure. And then if you look over to the right, it says, please send in additional information if you have it. So you can email it in, you can fax it in, you can send it through mail. However you want to do it, you can always give the analyst a little heads up as to what you're thinking. So when they go and process the claim, they already have an understanding that there may be some questions or concerns.
Perfect. Sounds good. And I know we're getting close to the end of time, so there is one question, and I think you guys have pretty much answered it. If you have a different answer, let me know. But there's a question about pre-existing conditions, and it's like buying a used car. So the question is, can employers see a workers' compensation history on potential candidates? And I'm pretty sure that that's a no because of the confidentiality of that injured worker.
Correct.
Cool. And then one other question, Maria, I'll ask this one to you. Is over-reporting to workers' compensation count against you? So should all work injuries, scratches, jam fingers, small falls, etc., be reported if the staff say they're fine and don't plan to seek treatment?
All claims do they have some effect on EMR. That's definitely something risk management specializes in more so than myself. But if they're not going to seek treatment, there's no lost time from work. Have them submit it internally with the employer. And then if they do want to submit it to workers' compensation, we're more than welcome to. And I know Charlene touched on it earlier that if the injured worker says they're not going to receive any medical treatment, we typically end up denying those claims anyway because there is no medical treatment sought for us to be able to pay any type of benefit on.
Great, thank you. I appreciate that. Let's see here. There's a couple things about deadlines for bills. It doesn't sound like there's a deadline for bills. That'll just be reviewed once those bills come in, and then there'll be determination if it's related or timely. Is that correct?
Yes.
Okay, and then let's see here. There's a question about the person's an employer relatively new to Wyoming. They called their payroll provider and they said that they need a workers' comp account in the state. When they called Wyoming, they were told that they didn't need an account because they have private coverage. So they're just confused about that. And where do we start in getting this corrected if there were any premiums or taxes paid? I think that it sounds like that they should probably contact the employer services division and work with them on that. Is that correct?
Absolutely. The
And
claims
then-
analyst isn't very knowledgeable on that aspect, so definitely reach out to employer services.
Awesome. And then there's a question about who's responsible for the initial treatment costs if a claim is submitted and approved. So maybe they've sought treatment before they had a claim number. They can still have that billed, right? They just need to provide the healthcare provider, I'm sure, the claim number.
Yep. Submit your claim number, send it to us, even if it's already gone through insurance, work with the healthcare provider and they can get that adjusted and switched over to workers' comp.
Perfect. Sounds good. It's 12 o'clock, so I just want to, I know we didn't get through all the questions. We got through most of them. I would encourage anyone that has leftover questions, the number is on the screen. Call that number, ask to talk to an assigned claims analyst. Or if you don't have a current claim and you just have general questions, we do have a customer service advocate that should be able to help you with that information. But we definitely want to get your feedback on this presentation. So a member of my team is going to put a link in the chat to our survey. Please provide us feedback. That's how we make these presentations and make sure we're getting you what you all want. And then we do have a presentation coming up next month. It's about AI, and we'll put that link in the chat as well. So if you want to learn about how to use AI in your everyday life, go ahead and sign up for that presentation. And we thank everyone today. Thank you, Erica, Charlene, Leah, Maria, for doing this for us. We really appreciate your knowledge and expertise in the field of workers' compensation claims, and hope everyone has a great day.
Thank you.